in the third series of lectures, that is part 3 on Digital Personal Data Protection Act 2023, we would like to discuss regarding transfer of personal data. So, under the Act, transfer of personal data for the purpose of processing is permitted to any country or territory outside India except to countries which have been specifically blacklisted by the government of India. The list of countries to which cross-border data transfers are not permitted will be notified by the Government of India. Further, data fiduciaries may transfer personal data to another data fiduciary or data processor only under a valid contract. While the Act does not provide any guidelines or requirement with respect to data contract regulating data transfer, such data transfer agreements may contain adequate indemnity provisions for a third party risk and may specify a mode of transfer that is adequately secured and safe. Additionally, the Act provides for certain indirect obligations on data processors which may be incorporated in data transfer agreements, and these include implementing reasonable security safeguards to prevent personal data breach or reporting of personal data breaches to the data fiduciary or erasing personal data upon receiving a communication to that effect by the data fiduciary and restricting transfer of personal data to countries which have been blacklisted by the government of India. So, in that connection relating to transfer of personal data, we would like to discuss certain instrumentalities of Government of India, such as the Reserve Bank of India, the Securities Exchange Board of India or SEBI, and the Insurance Regulatory Development Authority and the Companies Act 2013. So, in regards to India's central bank, the Reserve Bank of India has made it mandatory from 2018 for all payment system providers and their service providers, intermediaries, third party vendors, and other entities in the payment ecosystem to ensure that all data relating to payment system operates by them or stored in a system only in India. Interestingly, by virtue of this regulation, Reserve Bank of India is seeking storage of all payment system data in India, which includes the entire payment processing cycle from request to final payout, such as customer data, which must contain name, mobile number, Aadhaar number, PAN number, etc. Payment sensitive data, customer and beneficiary account details, payment credentials, such as the OTP number, PIN, passwords, etc., and transaction data originating and destination information, transaction reference, timestamp, amount, etc. However, for cross-border transactions, which consist of both foreign and domestic components, data pertaining to foreign legs may be stored outside India, while data pertaining to the domestic leg should be stored in India. A copy may be stored abroad. And now we would like to discuss another instrumentality of the Government of India, that is the Securities Exchange Board of India, has issued an advisory for financial sector Organizations such as the merchant bankers, credit rating agencies, STP service providers, debenture, trustees, depository participants, and other financial institutions which are availing the software as a service-based solution for managing their governance risks and compliance functions. The- This advisory also lists certain critical data sets such as credit and liquidity risks data, market risks data, system and subsystem information, supplier information system, configuration data, audit, internal audit data, network, topography, and design which must be stored in India. And more recently, the Securities Exchange Board of India has issued a framework for adoption of cloud services by regulated entities. If the regulated entities are engaged in cloud service providers to conduct their business functions, and any data pertaining to the regulated entities is on the cloud in any form, it is required to be stored within the legal boundaries of India. However, if the regulated entity has a foreign patent entity, parent entity, the original data is required to be available and readily accessible in India. This implies that a copy of such data which is on the cloud may be stored abroad. And also in connection to the Insurance Regulatory and Development Authority of India for maintenance of insurance records and regulations of 2015 has required insurance providers to store data related to policies and claim records of insurance on systems in India, even if this data is held in electronic form. And also, we would like to discuss regarding another important piece of legislation relating to Digital Personal Data Protection Act 2023 in connection to transfer of data. Section 128 of the Companies Act 2013 requires every company to prepare and store at its registered office books of accounts, other relevant books and papers and financial statements for every financial year. And it was from August 2022 the Ministry of Corporate Affairs amended this rule whereby all such relevant books and papers maintained in an electronic mode are required to remain accessible in India at all times. And as regarding the very system of security regarding the digital personal data, the data fiduciaries are required to protect the personal data under their control with respect to any processing undertaken by them or on their behalf by a data processor by taking reasonable security safeguards to prevent any kind of personal data breach, notably the highest quantum of financial penalty prescribed under the Act being 250 crores is the failure on the part of a data fiduciary to take reasonable security safeguards to prevent personal data breach. So, under the Act, significant data fiduciaries are required to appoint an independent data auditor who will undertake Periodic data protection impact assessment, which has been described as a process comprising a description of the rights of data principals and the purpose of processing their personal data. It also includes an assessment and management of the risks to the rights of data principals. And now we would like to discuss regarding the next provision relating to breach notification as provided under the Act. In the event of a personal data breach, a data fiduciary is required to inform each affected data principal and the board. The draft rules prescribe the manner in which the notification is required to be made, including the time period and the details required to be contained. Personal data breach is broadly defined under the Act as any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction of or loss of access to personal data that compromises the confidentiality, integrity, or availability of personal data. Therefore, data fiduciaries are requested to report all types of personal data breaches, regardless of the sensitivity of the breach or its impact on data principle. Under the Act, neither materiality thresholds nor express timelines have been prescribed for reporting the requirement. The Act is not the sole regulation imposing reporting requirement for data breaches. The existing cyber security framework also mandates reporting of cyber security incidents, which may include personal data breaches. In the absence of any conflicting information, both sets of regulations will be applicable. The Government of India has established and authorized the analyze to and disseminate information on cyber incidents, provide forecasts and alerts of cyber security incidents, provide emergency measures for handling cyber security incidents, and coordinate cyber incident response activities. The information technology, the Indian Computer Emergency Response Team, and manner of performing functions and duties rules 2013, along with the cyber security directions, impose mandatory notification requirements on service providers, intermediaries, data centers, and corporate entities upon the occurrence of certain cyber security incidents. Cyber security incidents have been defined to mean any real or suspected adverse events in relation to cyber security that violate any explicit or implicitly applicable security policy, resulting in unauthorized access denial or disruption of service, unauthorized use of a computer resource for processing or storage of information, change to data or information without authorization. Under the cyber security directions, the occurrence of the following types of cyber security incidents had to be reported, such as targeted scanning, probing of critical networks and systems, compromise of critical systems or informations, unauthorized access of IT systems and data or defacement of website or intrusion into a website and unauthorized changes such as inserting malicious code links to external websites. So also malicious code attacks such as spreading virus, worm, trojan, bots and spyware, ransomware and crypto miners. So also attack on servers such as database, mail and DNS and network devices such as routers. Also identity theft, spoofing and phishing attacks, denial of service and distributed denial of service attacks. So also attacks on critical or infrastructure, also attack on applications such as e-governance, e-commerce, etc. Data breach, data leak, or attacks on internet things, devices and associated systems, network software and servers, attacks on incidents or affects digital payment systems, attacks through malicious mobile applications or fake mobile applications or unauthorized access to social media accounts or attack or malicious suspicious activities affecting cloud computing systems, servers, software, applications, or attack or malicious suspicious activities affecting systems, servers, networks, softwares, applications relating to big data, blockchain, virtual assets, virtual asset exchanges, custodian wallets, robotics, 3D and 4D printing, additive manufacturing, drones, or attacks on malicious, suspicious activities affecting systems, servers, software, applications related to artificial intelligence and mechanic learning. So, data fiduciaries may review their data breach reporting protocols and assess each incident in accordance with the guidelines outlined in the Digital Personal Data Protection Act 2023. So now we would like to discuss regarding enforcement provisions. So, as referred to the IT Act, we found civil penalties as are prescribed under the Information Technology Act of 2000. So, if an entity that possesses, manages, or handles any sensitive personal information in a computer resource that it owns, controls, or operates is negligent in implementing and maintaining reasonable security practices and procedures, and its negligence causes wrongful loss or wrongful gain to any person, the entity was liable for damages to the affected persons. In the event of unlawful disclosure of personal information, the IT Act prescribes civil penalties which may extend up to Rs 25 lakh. So also separately cyber security directions have introduced penalty of a term of imprisonment extendable to 1 year or a fine up to Rs 10 lakh or both for failure to provide information or non-compliance with the cyber security directions. Under the Digital Personal Data Protection Act, civil monetary penalties on data fiduciaries ranging from rupees 5 crores or approximately from 25 lakhs or approximately have been prescribed for different contravention. The Act also provides for a penalty up to rupees 10,000 or approximately for the contravention of duties by a data principal. The quantum of monetary penalty will be determined by the board taking into consideration the following factors such as the nature, gravity and duration of the breach, the type and nature of the personal data affected by the breach, repetitive nature of the breach, whether the person as a result of the breach has realized again or avoided any loss, whether the person took any action to mitigate the effects and consequences of the breach, and the timelines and effectiveness of such action, whether the financial penalty to be imposed in proportionate and effective, having regard to the need to secure observance of and deter breach of the provisions of this act, and finally the likely impact of the imposition of the financial penalty on the person. The Government of India may amend the penalties that have been prescribed under the Act by issuing a notification in the future. However, the penalties cannot be modified to exceed double of the amount that has been specified under the Digital Personal Data Protection Act 2023. Currently, therefore, financial penalties may not be more than 500 crores even after amendment by the Government of India. And next important item that is provided under the Digital Personal Data Protection Act 2023 is regarding exemptions and also relating to electronic marketing, which we would like to discuss in our upcoming lecture.